Grenville's accession to the CCJ. Today is also important because today, I'm advised, Her Excellency the Governor General issued the writ for the referendum, which will shortly be placed in the Gazette and in the newspapers. So we're on the way for a referendum on the 6th of November. This is also important to give you the opportunity to listen to in-depth discussion on the CCJ and the merits of the CCJ. But more importantly, it gives you a chance to engage us, to ask questions so that you're better informed in making that decision. It is now my pleasure to invite Ms. Mina Booker, a member of the St. Andrew Development Organization, to make welcome remarks on behalf of the St. Andrew Development Organization. As I mentioned before, this evening's event is jointly presented by the CCJ Advisory Committee and the St. Andrew Development Organization. I invite Ms. Booker.
Sir Dennis Byron, President of the Caribbean Court of Justice, Sir Lawrence Joseph, Chairman of the CCJ Advisory Committee, Mr. Roger Ferguson, Mr. Robert Branch, and other members of the Advisory Committee, Parliamentary Representatives, Honorable Yolande Bain, Senator Kate Lewis, and Honorable Delma Thomas, Minister of Public Utilities, Work and Transport, Honorable Gregory Bowen, and Senator Winston Garraway, Mr. Glenn Noel, media, audience, a pleasant evening. It is my pleasure to welcome one and all to this evening's session. Special welcome to our feature speaker, Sir Dennis Byron. CEDU has been assisting the committee since 2016 with its public awareness sessions within the St. Andrew Parish. We are happy to welcome everyone this evening, and on behalf of the St. Andrew Development Organization, once again, welcome.
It is now my pleasure to invite the Honorable Attorney General, and who is also the Chairman of the CCJ Advisory Committee, to make remarks.
Thank you, Mr. Chairman. Honorable Ministers of Government, and I see the Honorable Gregory Bowen, Minister for Energy and Works. I see Minister Bain Hosford, Minister for Agriculture, Mr. Kate Lewis. I am sure I have missed out anybody, and we have Minister Garraway, Honorable Delma Thomas. You're looking very big there, so. Honorable Dennis Byron, members of the head table, we have special Mr. Rogers Ferguson and Mr. Glenn Noel. Ladies and gentlemen, it's a pleasure for me to be here this evening to give introductory remarks with regards to the Caribbean Court of Justice. Sometime in May of this year, the Caribbean Court of Justice Advisory Committee was established by government. The main purpose of the committee is to ensure that the populace becomes fully educated on the implications for Grenada's accession to the Caribbean Court of Justice as the final court of appeal instead of the Privy Council. The membership of the committee comprises representatives of the two main political parties, as the National Democratic Party, the New National Party, and the National Democratic Congress, as if I didn't know. And other non-governmental organizations such as church organizations, the trade unions, the business community, the Grenada Bar Association. On Tuesday, 6 November next, Grenadians will be asked to vote either yes or no to a bill entitled Constitution of Grenada, Caribbean Court of Justice and Renaming of Supreme Court Amendment Bill 2018. The main purpose of the bill is to facilitate the amendment of the Constitution in order for the CCJ to be the final Court of Appeal for Grenada instead of the Privy Council, and to rename the Supreme Court of Grenada as the Eastern Caribbean Supreme Court, as other OECS countries have already done, instead of the Supreme Court of Grenada and the West Indies Associated States, as provided for in Section 105 of the Constitution. Inasmuch as the bill seeks to alter the Constitution of Grenada, the process for so doing has to be done in accordance with Section 39 of the Constitution. As a consequence, the bill was introduced for first reading in the House of Representatives on 15 May 2018, where it remained for 90 days before its debate and passage by two-thirds majority support on Friday, 7th September last, and a simple majority support on Friday, 14th September last, that's in the Senate. Accordingly, a two-thirds majority support by all electors voting in a referendum is needed to enable the Constitution to be altered. This referendum is scheduled for Tuesday, 6 November 2018, as I said. The referendum will ask a simple question. Do you approve the bill for an act proposing to alter the Constitution of Grenada, cited as Constitution of Grenada Caribbean Court of Justice and Renaming of Supreme Court Amendment Act 2018? If you approve, then you tick the yes box, and if you disapprove, then you tick the no box. On 29 August last, the CCJ Advisory Committee conducted an extremely successful launch of its promotional activities at the Grenada Trade Center. There we had Prime Minister of Barbados, Mia Mottley, in her own inimitable easygoing style, outlining to the packed Trade Center audience the advantages for Grenada to have the CCJ as the final court of appeal instead of the Privy Council. This evening, we have with us at this Deluxe Cinema the former president of the CCJ, Sir Dennis Byron, to give further elaboration on the same concept, with the theme being break the chains of colonialism for one united Caribbean. For this, we thank Sir Dennis for accepting the invitation of the CCJ Advisory Committee to be the featured speaker at tonight's meeting. As chairman of the CCJAC, I welcome each and every one of you to this most important interactive session. In order to put tonight's meeting in its proper context, I will take the privilege to outline to you the background of our present state of affairs here in Grenada. In the 15th, 16th, and 17th centuries, the powerful countries in the world were Portugal, Spain, France, the Dutch Republic, and England. In 1492, on behalf of Spain, Christopher Columbus sailed across the Atlantic Ocean and sighted the American continent. Since then, other nationalities from the other powerful countries followed. There was a continuous land grab for these countries for gold, timber, and tropical crops such as cocoa, sugarcane, and spices. On his third voyage across the Atlantic in 1498, Christopher Columbus sighted Grenada. And you know that I said sighted, not discovered. Ownership of Grenada changed hands a few times, but by the Treaty of Versailles, signed between the French and the British in 1783, Grenada eventually became a colony of Britain. In 1877, the British instituted a crown colony system of government, with the executive power being placed in the hands of a British appointed governor, who was answerable to the British government. It was not until 1956, after adult suffrage was granted, that elected members on the Executive Council were given the majority of seats with ministerial portfolios. That was during the time of Eric Gary. Grenada became an associated state in 1967, with Britain still controlling the external affairs of Grenada. On 7 February 1974, independent status was granted to Grenada, and the country was provided with its own constitution. The Constitution is a document which makes rules as to how the country should be governed. There are three arms of government: the executive or cabinet of ministers, which establishes policy; the legislature or parliament, which makes the laws; and the judiciary, which interprets the laws. The Caribbean Court of Justice and the Privy Council belong to that arm of the government called the judiciary. Just as Grenada, every other country relies on a good legal system in order to control the behavior of individuals within the society. In any society, disputes will arise. These may involve land disputes, disputes over contracts, and liability for a number of offenses. When these matters cannot be settled by negotiations or mediations, they may be taken to the magistrates' court or high court. From the magistrates' court, one can then appeal to the high court, and if not satisfied with its decision, then one may appeal to the Court of Appeal in accordance with Section 103 of the Constitution. And if still not satisfied, one may then appeal to the Privy Council in accordance with Section 104 of the Constitution. It must be noted, however, that over the years there have been very few cases which have been sent on appeal to the Privy Council. One of the main reasons for this paucity of applications to the Privy Council is that it is highly costly to do so. As a facet of its colonial domination, the Privy Council was established by the British government in order to facilitate the holding of a final court of appeal for its former colonies like Australia, New Zealand, Canada, certain colonies in the Far East, and the Caribbean. England itself, and please note, England itself does not use the Privy Council as a final court of appeal to hear the normal civil and criminal matters. England has its own final court of appeal. As time went on, when some of these colonies acquired independent status, Australia, Canada, and others, these countries abandoned the Privy Council and set up their own final courts of appeal. Independent countries in the Caribbean, including Grenada, are some of the few former colonies of Great Britain which still have the Privy Council as the final court of appeal. In the Caribbean, over the years, several discussions were held for the purpose of changing this situation. The records show that since 1947, a meeting of governors mooted the idea of having a West Indian Court of Appeal. In 1970, Jamaica tabled a resolution at the 6th meeting of heads of government of the Caribbean Community, which was held in Kingston, Jamaica, to establish such a court. However, it was not until 14 February 2001 in Bridgetown, Barbados, that Grenada, together with other CARICOM countries, signed an agreement establishing the Caribbean Court of Justice. This court has two jurisdictions, an original jurisdiction, which came into being in 2001, and an appellate jurisdiction, which came into being in 2005. Most CARICOM countries, including Grenada, have acceded to the original jurisdiction of the CCJ, which deals with the interpretation and application of the Treaty of Chaguaramas, which established CARICOM. However, only Barbados, Belize, Guyana, and Dominica have so far acceded to the appellate jurisdiction as their final court of appeal instead of the Privy Council. So far, the appellate jurisdiction of the CCJ has already made sterling decisions on many important cases in the CARICOM region. And there are several good reasons for having Grenada accede to the CCJ as the final court of appeal instead of the Privy Council. And briefly, I shall just go through them. Grenada will be honoring its treaty obligations, having signed the agreement in Barbados on 14 February 2001. 2. The CCJ is more accessible. It is an itinerant court, meaning that it travels from country to country, encourages electronic processing of cases. The headquarters of the court is based in Port of Spain in Trinidad, which is only a few minutes away by air. 3. Urgent matters are tried very swiftly. For example, the case of Professor Eddie Ventus versus the Chief Elections Officer of Barbados. This case was heard and finished within a few days of the matter being filed, even on a Sunday. It was heard. 4. An opportunity to build up a mature Caribbean jurisprudence. Jurisprudence refers to the science of law, which ascertains the principles upon which legal rules are to be determined and settles the manner in which new or doubtful rules should be treated. That is, judges from the region would be more acquainted with their cultural and sociological norms. The Privy Council-based judges would inevitably accommodate their own norms, whereas judges in the Caribbean would accommodate the norms of the Caribbean. 5. It is less costly, that is the Caribbean Court of Justice. The fact is that unlike the other courts, the Privy Council is based in England. It is highly costly in terms of lawyers' fees, application fees to that court, traveling from Grenada to London, and for accommodation in London for a week or more. It is not, you cannot say exactly how long a case would take in the Privy Council. It is estimated that in order to take an ordinary run-of-the-mill matter to the Privy Council, an aggrieved person here in Grenada will have to find approximately $150,000, approximately 40,000 pounds sterling. This is the main reason that over the years, very few matters have been appealed to the Privy Council from Grenada and indeed from other CARICOM countries. Of course, it depends on the type of case that you have filed before the Privy Council, and that would relate to the type of costs that you will have to put out. 6. Notice of cessation of Privy Council facilities, and this is very important. Remember, Britain does not use the Privy Council as a final court of appeal. Yet the taxpayers of England are spending their money to upkeep the court, the Privy Council. Only Commonwealth countries use the Privy Council. So, at any time, you can expect the government of the United Kingdom to give notice that they would cease allowing the facilities of the Privy Council to be utilized by CARICOM, by Commonwealth countries. And over the years, the number of Commonwealth countries that have been using this court have dwindled considerably. 7. An opportunity to break the chains of colonialism. Grenada is no longer a colony of England, it is an independent state. And 8. It's an opportunity to have one united Caribbean, especially in the jurisprudential sphere. All CARICOM countries are willing and able to support the CCJ as indicated in the signed agreement establishing the Caribbean Court of Justice. I submit that the Privy Council is one of the last vestiges of colonialism which exists in Grenada. Even if Grenada received independent status from Britain on 7 February 1974, the Privy Council remains as a distinctive colonial medallion around our necks. And I also submit that it is time to remove this medallion around our necks. Wikipedia has described colonialism as the policy of a foreign polity seeking to extend or retain its authority over other people or territories, generally with the aim of developing or exploiting them to the benefit of the colonizing country and/or helping the colonies modernize in terms defined by the colonizers. This definition seems quite appropriate in the present context. Grenada is no longer a colony. We have here a proud independent country. It is time that we break the chains of colonialism and join with our other CARICOM brothers and sisters and have one united Caribbean. In closing, I would just like to read to you a short poem. It is entitled Ode to the Caribbean Court of Justice. Break from colonialism, this is what to do. Have a united Caribbean, this is best for you. Break the chains that bind us to the colonial past. We say the Privy Council is the place to start. The Caribbean Court of Justice is the own Caribbean court, giving us good service with decisions of note. Easy access to justice is what we must promote. CCJ deserves it, so get out there and vote. Let's have true independence in the Caribbean. It's time we call the shots and not depend on Britain. One united Caribbean is what we all must want. Let's break the bonds from Britain and rely on our own plans. You say you want justice for the common man? Then rely on the CCJ for the right solution. The Caribbean Court of Justice for the ties that bind. So get in your section and leave the past behind. Thank you.
Thank you very much, Honorable Attorney General. Moving quickly along, I invite now Mr. Ruggles Ferguson, who is a member of the CCJ Advisory Committee. Mr. Ferguson needs no introduction. He's a former president of the Grenada Bar Association and is now currently president of OGBA. Mr. Ferguson.
Thank you, Chair, and may I adopt the protocol earlier established. Say a pleasant good evening to all. And may I especially recognize in the audience my good friend Joseph Roberts, the leader of the No Vote campaign. He's right there in the audience, the self-declared leader of the No Vote campaign. I see he has his contingent with him this evening. Welcome. I've been again asked to speak on the one independence of the court. Among the concerns people have about the CCJ is whether or not we can trust this court, whether or not the courts will operate under the influence of politicians. And in the case of Grenada, as the Grenada government plays an important role in the process of referendum, really what is it, or why is it that the government wants Grenada to join the CCJ? These are all issues, these are all pertinent issues, areas of concern that need to be addressed. And the first point I would wish to make, in response to criticisms of the government playing an active role, I always say leaders must lead and must lead from the front. Now, Grenada signed an agreement February 14th, 2001, together with other CARICOM countries to establish the court, and Grenada has both a legal and moral obligation to join the court. The court is not about Grenada. It's not a national issue. It's a regional issue. And if we are to achieve true regional integration, and we know the history of the regional integration process, then we cannot be entering into agreements and not abiding by those agreements. So the government has every right to lead its citizens into something, and I speak of government here, whether it's the current government in office or whether it is another party in office. That party, that government, I speak of government, not party, has a responsibility to our Caribbean colleagues to be part of the Caribbean Court of Justice, our own court. Now, unfortunately, as I always say, if others lead the charge in society, because this is not a government thing, it's a national thing, and all national leaders, whether in the trade union movement, in the business movement, in the youth movement, women's movement, civil society groupings, they all have a responsibility to be part of this campaign. And as I always say also, and that's why I take no issue with my friend Joseph Roberts, because that adds to the different voices, the different perspectives, add to the debate, and would assist us ultimately in determining whether or not we should vote yes or no to the CCJ. Now, the independence of that court. In the last session in the Trade Center, I did invite everyone to look at CNN, look at Fox News, look at the news out of the United States of America, where there is a feverish debate going on right now with respect to a nominee to the U.S. Supreme Court. I'm sure if you, when you leave here tonight and you turn on your TVs, you would see the name Brett Kavanaugh as the nominee of President Donald Trump for the U.S. Supreme Court to replace one of the retiring justices. Now, the U.S. Supreme Court can be equated to the Caribbean Court of Justice. It's the final court of appeal in the United States of America, just as the CCJ, once embraced by all Caribbean territories, will be the final court of appeal for Grenada if the referendum succeeds on November 6th. But look at the difference, and you can see the evidence yourself. The nominee for a vacant position on the United States Supreme Court, that person is nominated by the President of the United States of America. And the confirmation of that nomination comes from the Senate. Politicians straight. And the talk in relation to Brett Kavanaugh is whether or not all the Democrats will vote against him and possibly 2 or 3 Republicans coming across and voting against him. And there were some recent accusations against him, as you would hear, dating back some 36 years ago. But it's always in political terms, whether it's a Democratic nominee or a Republican nominee. Contrast with the Caribbean Court of Justice. 2 courts rolled into one. One court, which is like an international court that is responsible for interpreting and applying the revised Treaty of Chaguaramas. And that is the treaty that deals with free movement of people, of goods, of services, of capital throughout the region. Just as you can move from Grenville to St. George's, no obstruction, ultimately the idea is to have one Caribbean space. And you have free movement at all levels. And that free movement is governed by the revised Treaty of Chaguaramas. And therefore, if there are issues, as we have had many issues in the original jurisdiction of the court, then the same CCJ judges, it's 2 courts rolled into one, but it's the same judges of the CCJ who will be officiating over those matters. The same physical court in Port of Spain, the same judges who will sit in the appellate jurisdiction of the court. So, and Grenada, and I would say loud and clear for my friend Joseph Roberts to hear, because he has been accusing me of not making that point, that we are all part of the original jurisdiction of the court, and we use the famous Shanique Myrie example. And let me say, the example of the Shanique Myrie case, the Jamaican woman who was barred from entering Barbados and received the most humiliating treatment, including intimate body searches, and deported to Barbados the next day, yet to Jamaica, the following day. Yes, that case was in the original jurisdiction of the court. But why is it important to cite that case even though it's an original jurisdiction case? Simply to show that the CCJ is not in the pocket of politicians, on the one hand. That the CCJ ruled against Barbados, probably one of the biggest supporters of the court. And so Dennis would no doubt tell you more about judgments against Barbados and other governments in the region in the last 13 years of existence of the Caribbean Court of Justice. And the second reason, so as of tomorrow morning, my friend Joseph, please set the record straight. The second reason for using the Shanique Myrie case, even though it's in the original jurisdiction of the court, is access to justice. Because the CCJ is a traveling court, itinerant court. And for the Shanique Myrie case, she was in Jamaica. She gave her evidence in Jamaica. The court went to Jamaica to hear the evidence of the Jamaican contingent. The court then went to Barbados to hear the evidence of the Barbados contingent. And then the court gave its ruling via video conference from Port of Spain, Trinidad. And that is same approach to the appellate jurisdiction of the court. So that is why the Shanique Myrie judgment is so important. 1, the independence of the judges, and 2, the accessibility of that court. Now, I use the U.S. example in relation to independence. And when you think about the Caribbean Court of Justice, you think about 2 key institutions that affords that independence. These institutions don't exist in the United States of America or even the United Kingdom. And these are judiciaries that we respect. One structure is the CCJ Trust Fund. The CCJ Trust Fund. And that is the fund that manages the monies invested by Caribbean governments into the CCJ way back in 2004 for the operation of that court. Caribbean governments raised $100 million US and put it in the hands of a trust fund to manage those funds. And it's really managed, and the fund is guided by investment experts throughout the United States and other countries. So you have professionals. The Board of Trustees take policy decisions. They take policy decisions, but those monies are under the watchful eyes of the experts in the United States and elsewhere. So that $100 million is what funds the court and is expected to fund the court in perpetuity. Of course, if money runs out for whatever reason, then Caribbean governments, it's our court, would be expected to give an injection, but not directly to individuals. It's to the trust fund so it can manage. And who comprises that trust fund? Very briefly, the Secretary General of CARICOM, or his nominee, the Vice Chancellor of the University of the West Indies, the President of the Insurance Association of the Caribbean, the Chairman of the Association of Indigenous Banks of the Caribbean, the President of the Caribbean Institute of Chartered Accountants, the President of the Organization of Commonwealth Caribbean Bar Associations, the Chairman of the Conference of Heads of Judiciary of Member States of the Caribbean Community, the President of the Caribbean Association of Industry and Commerce, and the President of the Caribbean Congress of Labor. You know that? You're talking about all the sectors within the Caribbean community involved in the management of that trust fund. You have academics from the University of the West Indies, you have bankers, you have insurers, you have accountants, you have senior judicial officers, you have lawyers, you have labor represented, and you have the business community represented. What could be more democratic than that? So the people, we the people, are actually involved in the management and operation of the Caribbean Court of Justice. And if you noted all the categories I called, not one single politician props up. And at the end of 2017, the report from the CCJ Trust Fund was that there was $87 million of the $100 million because the operations of the court would be funded through the interest of the trust fund and other investments. In other words, that $100 million is expected to multiply and make more money down the line. Now, I pause here to say that today marks the opening of the law year, 2018-2019. And it's marked by the delivery of an address by the Chief Justice, who was in St. Kitts this week via video conferencing facilities to the 9 courts throughout the region. And you know, there were bitter complaints today. I know the complaints. 1, governments owe the court over $22 million in arrears. Over $22 million in arrears. Can that happen to the CCJ? No. Government can't owe arrears simply because, and as she lamented, the OECS code does not have a trust fund. So they depend on the budgetary provisions every year made by the governments of the OECS. And if those governments don't pay their dues, then you have problems with the funding of the court. I have an announcement. Driver of P7441, your vehicle lights are on. Driver of P7441. So here is it. And there might be that issue of the complaints about the OECS court and funding that affects people's own view of the Caribbean Court of Justice. But learning from the experience of the OECS and the other courts, then governments put their money up front, and those monies fund the court. The other structure you must remember when thinking of CCJ is the Judicial and Legal Services Commission. And I need not say much on that because the flyer you got this evening addresses that issue, the JLSC. And why is the JLSC important? So the trust fund is important for independent funding of the court. And the JLSC is important for the independent appointment of judges, not the president. In the USA, the president does it. In the Caribbean, the JLSC, Judicial and Legal Services Commission, that comprises 11 members, they appoint the judges. If you want to be a judge of the CCJ, you don't write to the politicians of the region. You don't write to the head of CARICOM. You apply to the Judicial and Legal Services Commission and you go through the screening process. And they can appoint you without any reference to the politicians of the region. And that institution has no politician, not one politician sitting on it. Who sits on the JLSC? Listen to the membership of the JLSC. The president, and Sir Dennis was the president up to July 4th or July 3rd. You have two persons nominated by the Organization of Commonwealth Caribbean Bar Associations and the Organization of Eastern Caribbean States. You have one chairman of the Judicial and Legal Services Commission of a contracting party. So that means you would have a person from the JLSC of the Eastern Caribbean, and in fact, Dame Janice represents the Judicial and Legal Services Commission of a contracting party. When her term ends, might be the Jamaica Chief Justice or some other Chief Justice will, and they serve in rotation every 3 years. Then you have a chairman of a Public Service Commission of a contracting party, selected in rotation for a period of 3 years. Two persons from civil society nominated jointly by the Secretary General of the Community, that's CARICOM, and the Director General of the OECS for a period of 3 years. And two distinguished jurists nominated jointly by the Dean of the Faculty of Law of the University of the West Indies, the Deans of the Faculties of Law of any of the contracting parties like the University of Guyana, and the Chairman of the Council of Legal Education. So you have folks who are involved in the legal process who make these appointments. The University of the West Indies, Hugh William Law School, Norman Manley Law School in Jamaica, the Eugene Dupuch Law School in the Bahamas. All of these have central roles to play in the appointment of persons to the Independent Judicial and Legal Services Commission. Again, not one politician is on that body. So you have two totally independent bodies, JLSC, appointing judges, and CCJ, trust fund, financing the court. The only time the politician becomes involved, the heads of government, is when the president, so when Sir Dennis was demitting office. Of course, there were applications for the new president of the CCJ. That goes to where? The Judicial and Legal Services Commission. They do these elections. They make the recommendations. The heads, they might send a short list of 3 persons, and the heads are restricted to those 3 persons as far as selection goes. Sorry? Right, 1 recommendation. But if they refuse the recommendation, of the JLSC, they can't then select somebody arbitrarily at the end of the day. The JLSC must put its stamp of approval on that nominee. Not so with President Trump in the United States of America. He can select whomsoever he wishes. And of course, the Republicans would want to ensure that the final court in the United States, the highest court, remains a conservative court. Not so, Jerry? Indeed. So, the independence of the court is critical because that is where people, our Caribbean people, have probably the most problems in terms of trust and confidence. And I would just end by making these final 2 points. You hear every day now fixing the local court first. Yes, we support CCJ, but get your priorities right. Lots of fixing to do in the local court system. Let's fix it first, because these are the lower courts, and then let's get to the CCJ. If you can't get justice down there, according to my good friend Joseph Roberts, then why are we spending time up there? I have no problems with the position submitted. I agree wholeheartedly that we need to fix our system, and we have many things to fix in our system. Facilities in the court, delays, backlog, just about everything we have to fix. But that argument is presented as though Grenada is about to build a new court to house its final court of appeal and to pay judges while the bottom level of the structure remains unattended. And as attractive as that argument sounds, respectfully, it has no merit. It has merit insofar as the man in the street, that is what he sees. And of course, it's important to fix that. But you know what the real issue is? We are paying for a Caribbean Court of Justice. Grenada borrowed its fair share of money more than 13 years ago to finance that court, and we're not using it. Grenada will not be paying 1 cent more. 1 cent. I'm not talking about dollars. If it accedes to the final jurisdiction of the CCJ. So let's deal with the top, deal with issues at the bottom, but dealing with the issues at the top would not effectively interfere adversely with the issues at the bottom. And my final point is about the debate. The debate. That we need to debate this issue more. And I agree too. I agree. But everyone is invited to join the debate. And that's why I'm so happy that my friend Joseph has declared himself to be the no vote man. Because I heard him recently, and at the end of it, he points to the areas that we need clarification on. There are certain misrepresentations out there, and I'm sure not deliberately so. But when we have all perspectives, it's much easier to take a decision. But let me say, that debate has been going on for 117 years now. the Jamaica Gleaner in its editorial in 1901 were advancing some of the same reasons we are advancing today to have our final court of appeal in the region. I was involved in the debate heavily between 1999 and 2003 at the level of the bar associations, and our insistence that before we have a final court, we should have independent financing and an institution responsible for the independent appointment of judges. And those came true. And that is why I have reshaped my position over the years and become an advocate of the CCJ. I may have been one of those with concerns, and that is why in the Bar Association, we have had about five of our Sir Archibald Ned presentations on the CCJ versus the Privy Council. So the debate is going on. I expect it to intensify. And I am open to any challenge from anybody from the other side of the aisle who wishes to square off with me on the issues of the CCJ. That's an open invitation. Thank you.
Okay, thank you very much, August. I hope there will be no need for you to square off this evening. We want to thank you for your presentation, very clear presentation on the two important institutions of the CCJ, the Trust Fund and the Regional Judicial and Legal Services Commission. It is my pleasure now to invite Mr. Glenn Noel. Mr. Noel is no stranger to us. He's a prominent and senior member of the opposition National Democratic Congress. He is a former senator in the NDC administration and is currently the General Secretary of the National Democratic Congress. As you know, this process is non-partisan, non-political. It always has been, and we welcome Mr. Noel to make a presentation on the issue of the CCJ. Mr. Noel.
Thank you very much, Mr. Master of Ceremony. I want to associate myself with the protocol already established, recognize the ministers of government and members of the head table, and to particularly welcome Sir Dennis Byron. Ladies and gentlemen, brothers and sisters, I know that many of you are quite curious, and that is natural, in the sense of wondering why I'm here and what is it that I'm going to say. Well, first of all, you notice that I'm clad much more liberally than my other members, in the sense that I'm an ordinary man. Now, on my way here, many persons asked me if I was going to speak on my own behalf and if I'm speaking on behalf of the party. But I believe that as a principle, you really can't separate the two. Because if I come here and I give my opinion, I'm the General Secretary of the NDC, and whatever I say to you will be perceived as the party's position. So I would not separate the two. Many people make that mistake, but they shouldn't. Now, the struggle to build the Caribbean civilization has begun a long time ago. And we passed through Crown Colony, associated statehood, independence, but we continue to try to build Caribbean institutions and to improve our standing and develop our own society. And so we had the establishment of the University of the West Indies. And I'm certain when the University of the West Indies as an institution came into being, there would have been a lot of debate about the merit of it. Is it reliable? Should we depend on ourselves? Should we not depend on at that time, the GCE? Is it not more superior and will be recognized internationally? And all those debates took place. And so when we came to the CXC as well, and UE, and the CDB, all of these are Caribbean institutions. And I'm certain that the CCJ is just another step. And the CCJ would not be the final step in ending the reign of colonization in the Caribbean, because many of the countries are still Commonwealth. So I'm saying that such and that journey will continue. And I'm sure we'll get to a point someday when many countries may become republic. So what is our and what is my position on the CCJ? First and foremost, the NDC and I not opposed to the CCJ. But I want to say to you that the CCJ would not come into reality unless we change our attitude in the way we do business, in the way we approach issues of national development and issues that concern Grenada. Because in order for the CCJ to become a reality, there must be a bipartisan approach. In other words, it's not an NDC thing, nor NNP thing. And unless we come together as a people, it cannot be achieved. Why? You need 2/3 of the electorate in a referendum to ensure that that happens. What the reality tells us, at this moment, there may be about 78,000 persons on the voters list. And if we observe the last 3 or 4 elections, 2003, what happened? The NDC got just over 21,000 votes. The NNP got just over 22,000 votes. There's a reason why I'm going that route. And I'm presenting something new and different, right? We look at the results of the 2008 election, we recognize what occurred. And then we look at 2013 and 2018. And what we see is that in the 2013 and the 2018 elections, there has not been any serious movement in terms of the NDC support, nor the NNP support. Because they both got just over 33, the NNP got over 33,000 votes, the NNP got just over 23,000 votes. What does that tell us? It tells us that over 40% of the electorate, whether you like it or not, still support the NDC, and just over 58%, which is short of the 67%. So in other words, even though this is not a partisan issue, but the divide in Grenada is a very polarized place where people see things in politically. If the Prime Minister of Grenada says that the sky is blue, there are people who look out there and see that the sky is blue and still say the sky is gray. Am I speaking the truth? And there are people, once a message comes from the NDC, they just close to it. And I'm saying that if we ought to achieve the CCJ and other things, we cannot go forward with this kind of mentality. What it means is that we have to take a bipartisan approach to those issues. But you see, we can't just choose the issues unilaterally, deliberately, in an opportunistic way that we want to take a bipartisan approach to. If we agree that all that is good for Grenada, then everybody must get on board and support it. then in this regard, I wish to put forward the following reason and the following issues. I wish to say that as far as we are concerned, in fact, we had a very good meeting today. I wasn't at the meeting, but I was told from my members, my brothers and sisters, and I was told by Sir Lawrence himself that the meeting was very promising. And it's a start. It's a start of saying that what we need to do, we need to come together and to discuss those important issues that affect all of us. And sometimes out of those discussion and struggle, I can tell you that in the middle 90s, in those days, maybe I was a little bit revered and in some cases feared and in some cases seen as a troublemaker. But I remember that year we had this struggle. There was an understanding that around the carnival season was supposed to be a closed season in terms of bringing in foreign artists and especially extra regional artists, artists that are not Calypsonians. And it wasn't law, but we had a common understanding. And we felt strongly about it. And there was this promoter that contracted Red Rat, which was a Jamaican artist, to come in to perform around that time. And as the president of the Calypso Association in those days with the Calypsonians behind me, I say, listen, as far as I'm concerned, you breach an important understanding, and we're going to close on every single one of the tents and not open one for Carnival, if that is going to happen. We had some to and fro. In the final analysis, we had a meeting where we sat down with the Minister of Labor, who was then Senator, at that time he was Senator Lawrence Joseph, the Minister of Labor. And in the final analysis, with all the difficulty and all the noise on the radio and threat and everything like that, we were able to sit down and come to a solution. And the solution was that because of the preparation that was made and the whole issue of the possibility of lawsuit and so forth, it would be difficult for them to go back on not having the show. And we agreed that the tents were going to be compensated and to be given some money so that they could compensate for the shortfall that they may have competing with that show. And that was the birth of government subvention. There are many people who believe today that this is something that was just given and it just happened like that. But that was the birth of subvention for all of the associations and Calypsonian groups and so forth. That is how it began. So I'm just saying that compromise sometimes in the midst of struggle lead to development. And sometimes we must learn from things like that, right? So we are very concerned and we are prepared because we believe that there are a number of issues that face in this country that is beyond the narrow confines of political parties and partisans and so forth. We believe that anything that is good for Grenada is important for us to examine it, and once we deem that Grenada can benefit from it, is to give it our support. But we believe that this must not be a one-sided affair. In other words, it must not be a situation where one side deem what is important for them and they look for your support at that particular time, and then when it suits them, they don't. We believe that there must be some clear issues that we agree on and we work together. So we want to use this platform to also say that as important as the CCJ is, and it is important, that the whole question of the reform of the People's, of the Representation of the People's Act, the RPA, is an important and serious issue for us and for Grenada as well, because it affects our democracy, our way of life, and it affects many persons. And we believe that there are some issues that we can work together and to reform for the benefit of all of us. And we also want to put it on the table and ask for a commitment and an understanding that we single out those issues that affect the nation. So CCJ is one, RPA is one, and we work together on those issues because it's as important as well. I also join with the view, and while I would not say that you must fix what is happening in the lower court, because I recognize that it's an ongoing process. The issue of justice and the justice system and the reform of it is an ongoing process. It not only affects Grenada, but I can tell you too that some of the other islands in the region is just as bad in terms of the facility, government location, in terms of allocation of resources and money and so forth. And that may need a regional approach. There are some promising signs in the sense that recently the whole issue of the mediation centers and all those things are improvement. But we have a long way to go to ensure that justice is dispensed for the ordinary man. So when you look at the situation with the registry, when you look at the situation with the backlog of cases, we are concerned about all those issues as well. And we want to put those issues together with CCJ on the table as to things that we must work on. As to the contents and the merit of the CCJ, I don't want to get into the argument at this moment, although I have a perspective and have some positions on it that I will express later. As it relates to the actual content of the bills, I'm looking at it at the moment still, and we can always debate on the bills itself, but I'm not here to talk about that. I'm saying that our generation, we have a responsibility to stop the polarization and the divide. And this is not a call only from one side, because one of the main reasons why the referendum failed is because we did not take a bipartisan approach. The NDC, for what it was, saw this as a political struggle and as something that we must ensure. Though we had concerns for individual bills, but generally, overwhelmingly, the majority of NDC supporters were not prepared to support the bill, as you know. And the NP did not see it necessary to reach out in the way that they ought to in terms of getting the kind of bipartisan support for the process as well. And even as we speak here, sisters and brothers, let us not pretend. The CCJ is not a sexy topic. So for many of us, intellectuals and many professional people, we might be attracted to the whole idea. But if you move around the villages, you will recognize that not a lot of people are into it, and people are very skeptic on both sides of the aisle. And it will take an effort to get them to trust the system and to trust the way forward. Because people are so polarized that nearly everything, they see politics in it, whether you like it or not. And so tonight, I'm not getting into the intellectual debate. I think there are very capable person at the head table that can do that. I am simply saying that what we need to do to achieve issues that affect all of us nationally, it calls for a new dispensation, a new way of thinking. And we have to put aside the petty politics. You win, you lose, I lose. And we have to decide that we must come together and work for the good of Grenada. And I say this as somebody who have been in the trenches, somebody who have been a fierce warrior, somebody who have been at the lowest. I've also been at the level where I was a senator and a minister of government. But I'm very clear in my mind that I have a duty and a responsibility to try and narrow that gap and to find ways to compromise and to work together and to achieve things for the whole of Grenada. So tonight, this is my sole message to you. But as we move along, I will get deeper into the actual debate about the merits of the CCJ, about the bill itself, and those other issues. But I just wanted to make this important point. Thank you very much.
Thank you very much, Mr. Noel. I now invite Mrs. Michelle Steele to introduce Dennis Byron, our feature speaker. And while she's coming to the podium, I again want to
midst to speak to us about this very important issue. If you have a question about the CCJ, this is the man to answer it. We are here to debate whether Grenada should accede to the appellate jurisdiction of the CCJ. Grenada, it is very important to know, we are already part of that court in its original jurisdiction. We as citizens are entitled to access that court, just as Shanique Myrie did, if we feel that any of our rights as CARICOM nationals to freedom of movement, freedom of trade have been infringed, or any of our rights established by the Treaty of Charagaramas have been breached. Sir Dennis, in my reflections of Sir Dennis over the years, for some of you who may know me, you know that I'm a part of the legal profession. So I have been in contact, or I would have encountered Sir Dennis as a very young lawyer. I'm not going to tell you my age. But over the years, I realized that if someone used the following phrases to describe him, they would be correct on all counts. A friendly face greeting young lawyers in our first appearances before the Court of Appeal. A daunting and imposing figure facing the bar table from the bench. In other words, don't bring any nonsense for him and be prepared. A brilliant jurist who has received international recognition. A change agent and advocate for efficiency and accessibility in the administration of justice. A giant of a man, indefatigable on his path a legal luminary, a gift from the small island of St. Kitts. And the list goes on. Sir Dennis was born in Basseterre, St. Kitts on July 4th, 1943. He is the first born of his parents, Vincent and Pearl Byron. He studied law at Cambridge University in the UK, and in 1965 he was called to the Bar of England and Wales by the Honourable Society of the Inner Temple. Sir Byron returned to his homeland and he enjoyed private practice from 1966 to 82. So he's grounded in the arena. His judicial career began in 1982 when he was appointed as a High Court judge of the Eastern Caribbean Supreme Court. In 1999, he was appointed Chief Justice of the Eastern Caribbean Supreme Court, having acted in that position for 2 years. It is at this stage that Sir Dennis really started to make his mark in the administration of justice, and he continues to do so to this day. In 1997, he launched the Judicial Education Institute as a committee of the Chief Justice's chambers, so he would have had oversight in producing a code of ethics for judges. He organized a series of seminars and training programs providing orientation for judges, lawyers, and trial court registrars. So the education began. This paved the way to modernization of our court, and Sir Dennis introduced the new Civil Procedure Rules 2000, which is our current regime, which came into operation on the 31st of December 2000. This introduced case flow management to the civil process. And with these reforms, Sir Dennis set a threefold objective: the enhancement of public access to the court by simplifying procedures. There were times when we had, remember, the plaintiff and the defendant. Simple things like changing that terminology to the claimant and the defendant, trying to make these rules a little bit more simple and easier to understand, not just jargon for lawyers to know all about. He reduced the delay in litigation, and there was the inculcation of a higher standard of professionalism at the bar. In the old days, lawyers could go to court and at the last minute when you get to trial, say, I have to amend my pleadings. Sir Dennis has put a stop to that. None of that nonsense. You have to be ready, you have to have your paperwork ready, and you're not allowed to amend after a certain period of time or a certain stage in the procedure so that we can move forward in a faster manner. In March of 2001, Sir Dennis, as he then was, as a member, Chief Justice Byron, as he then was, as a member of an international delegation of jurists, traveled to Zimbabwe on a fact-finding mission on behalf of the Human Rights Institute of the International Bar Association, inquiring into reports of abuses against the rule of law by the government. Mr. Justice Byron was subsequently appointed by the United States Nations Secretary General to replace Judge Lloyd George Williams, where he served as a judge of the United Nations International Criminal Tribunal for Rwanda from June 2004. He was elected president of the tribunal in May 2007, succeeding the then former president Erik Mose of Norway, and was re-elected for a second term as president in May 2009. As president of the tribunal, Justice Byron, as he then was responsible for the overall management of the court and for liaising with member states as well as the UN Security Council. He led the implementation of ICTR strategic policies and the management of its external relations. While at the ICTR, Judge Byron has sat on 7 trial benches and served on a number of pre-trial benches. Sir Dennis has a particular interest in judicial education activities, and he has been the president of the Commonwealth Judicial Education Institute since the year 2000. In 2000, he was knighted by Queen Elizabeth II, and he was appointed a member of the Privy Council in 2004. In that year, he was also appointed an honorary bencher of the Honorable Society of the Inner Temple. He holds the first Yogis and Keddy Chair in Human Rights Law at Dalhousie University, Nova Scotia, Canada. In 2001, he took the oath of office as President of the Caribbean Court of Justice in his home country, or 2011, before His Excellency Sir Cuthbert Sebastian, Governor General of St. Kitts and Nevis. His inauguration comes further to his appointment by the Conference of Heads of Government upon the retirement of the former and first President of the Court, Sir Justice Michael de Labastide. He's also married, he finds the time, and he has 6 children. Ladies and gentlemen, please join me to welcome our guest of honor, Sir Dennis Barron.
Thank you very much. I also adopt all of the protocols which has been established, and I'd just like to say how happy I am to be part of this very important meeting tonight. And I'd like to thank the persons responsible for inviting me to share in this evening. I must thank Ms. Steele for that wonderful introduction of me. Ms. Steele, you know, I've started to say almost quite frequently, and I feel like saying it again tonight, that after hearing that wonderful introduction, I think I should just say thank you and sit down while you still have a good impression of me. But I know I can't do it. You know, this is a very, I must, before I go and move into my what I wanted to say, I thought that the evening has already produced a very tremendous reservoir of knowledge and learning. The quality of the presenter, all of the previous presentations, I thought was quite extraordinary and has presented you with a foundation of knowledge and information which will be very helpful in the exercise that you have. And it also saves me having to say over a number of important matters. But I want to single out Mr. Noel, because he tackled, I thought, a very important and difficult topic. And it's something which goes to the foundation of all of these discussions on the CCJ, but it even goes beyond that. It goes to the question of how do we improve the quality of life in our islands in the Caribbean. So I know he was treading on a very difficult subject, and I want to congratulate him for the honesty and the courage to confront it in the way he did. And I wish him and all others who join in this idea of putting the interests of the people of Grenada before party political issues, I want to wish you all well. And hope that the community will follow your example and be motivated in the way in which you have suggested as they assess this important question. Now, this morning I spoke to the T.J. Marishaw School, and towards the end of the session, a lady got up and asked a question. And what she said was this: she'd been listening to the discussions, They were all fairly informative. But when she was invited to the meeting, she expected to be given about 6 reasons why she should vote for the CCJ and not for the Privy Council. And she didn't hear me say reason 1, 2, 3, 4, 5, and 6. Now, at the time when she asked the question, the other persons intervened, and I didn't respond to her directly. And I would like to start tonight where we finished this morning. And I do hope she's listening, and that it will be also of interest to you. So I listed 6 reasons for abolishing appeals to the Privy Council and acceding to the final appellate jurisdiction of the CCJ. Reason 1, joining the CCJ appellate division will improve access to justice. One of our previous speakers, the Honorable Attorney General, had mentioned that very few cases from Grenada go to the Privy Council. And I think it was Mr. Noel who said that people in the villages don't relate to the CCJ and the Privy Council, because the Privy Council has not really played any part in the life of ordinary people in our society. But the countries that have acceded to the final appellate jurisdiction of the CCJ send several cases to the CCJ every year. And during this year, and it's just September, from the 3 countries who have sent cases before us, we have already received 25 cases. So the ordinary folk are now having an improved opportunity to access a final tier of justice. Reason number 2, joining the CCJ appellate division will allow the CCJ to impact the daily life of people in this community by making decisions that correct injustice in ways that are not currently addressed by the Privy Council. Now, later on this evening, if you don't get bored with me, I will give you examples of some cases where we have done exactly that. Reason number 3, joining the CCJ appellate division will allow the CCJ to introduce reform measures to improve the quality of justice delivery and also deliver judicial education programs. Issues that the Privy Council does not address in the Caribbean, although the judges who sit in it might do it in England. And I think that in Grenada, you have already seen examples of the work of the CCJ in this regard, when we assisted in removing the civil law backlog about 2 years ago, and other issues that we have dealt with. This also can be developed if necessary. Reason number 4, joining the CCJ appellate division will allow ordinary folk to use the technology of the court to access justice in ease and comfort and without having to spend too much money. The court has low costs of filing fees and a system to exempt poor persons from paying those fees in deserving cases. Now, it is very interesting that when Mr. Ferguson was speaking, he gave an example of the court being an itinerant court in the Shanik Myrie case. Now, we don't go often to hear cases. But the reason why we were itinerant in the Shanik Mary case was because Shanik Mary was a person who was not connected to money, to power, to influence. And we knew that if she had to pay to bring her witnesses to Trinidad, it would have imposed a burden on her. And in order to make it easy for ordinary persons to access justice, we took the court to where she was in Jamaica. And I can give other examples of steps taken by the court to allow ordinary folk to have an opportunity to access justice at our level. Reason number 5. Joining the CCJ Appellate Division will allow ordinary folk right here in Grenville to see the work of the CCJ as an example which could uplift local judicial performance. Timely hearings, timely delivery of judgments, transparent and open proceedings. I'm telling you, all proceedings of the CCJ are live streamed. Every one of you can stay at home and see the court in operation, every case. And the cases that have already been heard, the video recordings are on the CCJ website, and you can access them and see the court at work. All the judgments of the court and a lot of other work that the court does is posted on the website so that you can identify with the work of the court in ways you cannot identify with the Privy Council. So here we have a court that is open, transparent, and you can have complete access to all of our activities in this manner. And I know that I'm told that Grenada is a high-tech community. So any of you can access the CCJ website. All you have to do is to put in Google, Caribbean Court of Justice, and it will direct you to the link to access the website, where you can get access to all of this information. And reason number 6, joining the CCJ Appellate Division will allow Caribbean people to be on an equal footing with human beings all over the world, where justice is managed by each community and not outsourced to a foreign power. So I stopped there. I could go on and find other reasons, but I think I kept my promise to provide 6 reasons, the 6 reasons that was requested this morning. Now, Madam AG Secretary and Mr. IT Technician, I need you to help me. One of the other issues that was raised this morning was that the court has been functioning for all these years. It is not an idea in somebody's imagination. They are real people who are judges on the court. So when you're talking about trust and confidence, you're not talking about an idea, you're talking about real people. But I was told that people don't know who the judges of the court are. And so what I did, I prepared a little bit of a Vimeo just to give you a 5-minute snapshot who the judges of the court are. Are you able to open a computer? Huh?
Is used to is a final court, which is on the other side of the ocean. Everybody seems to think that that is normal. I would say exceptionally abnormal. Look around in the world and you will see that most countries have their own final court of appeal.
And I think that the CCJ is a wonderful place to set an example, to lead the way as far as things like judicial reform is concerned. The things that are important, not just to judges, but to the people who come.
Diversity is important in that we are representing a collection of islands of the Caribbean. So if we had 7 judges all from one island, it would obviously be unsatisfactory, or 7 male judges or 7 female judges. But it is important that you get judges who come from diverse backgrounds, because of which affects their upbringing, of course, and their outlook, but also, of course, their understanding of the law. The fact of the matter is that we live in the Caribbean as judges of the CCJ. Most of us are from the Caribbean, such as well. And we are intimately aware of the circumstances affecting Caribbean societies. And one of those circumstances is the fact that many of our people, young people, are in the bond sentence for very, very long periods of time before they are tried. Now, in circumstances where they are tried for not guilty, that opens up a whole range of questions to be answered at some point. The value of the CCJ, the value of any apex court, lies not just in the decisions that it hands down. In every country, the apex court, the president of the apex court is very much involved in, for example, judicial education. And it was so important that we utilize the Caribbean entities to develop customized solutions that circumstances where we are trying for not guilty, that opens up a whole range of questions to be answered at some point. The value of the CCJ, the value of any apex court, lies not just in the decisions that it hands down. In every country, the apex court, the president of the apex court, is very much involved in, for example, judicial education. And it was so important that we utilize the Caribbean entities to develop customized solutions that would reflect our needs and allow us to perform to the international standard. So I think that tool that we can Caribbean jurisprudence includes developmental solutions to improve the way the justice is delivered in our courts.
Can you stop that? Sorry. Well, some music overpowered my presentation. But I hope that you got the gist. The court comprises, I gather that people wasn't aware, that the court comprises judges from Jamaica, Justice Anderson, from Trinidad, our female judge, from St. Vincent, the current president of the court, from Belize, Justice Barrow. We also have a judge from England, Justice Hayton, and a judge from Holland, Justice Witt. And my computer wants to have a life of its own, Yeah. But that gives you a snapshot. What I can do, though, I can leave the video with the committee, and it can be replayed, cleaned up and replayed, and provide some more information to you all. Now, I had inquired about issues which would have been of some interest and concern, and in fact, most of the information I received has been mentioned to some extent this evening. Now, I was asked to explain to you what is different in terms of legal costs for a litigant who does not have the means to appeal to the CCJ as to the Privy Council. And I understand that questions are still being asked about what the CCJ is costing Grenada. Now, Grenada, as you have heard, in 2004, made its full contribution to the trust fund of $100 million. And the interest from that trust fund has been paying the court's budget for the last 14 years, and the money is still there. Grenada has not had to pay any extra money since then for the maintenance of the court. So there's an extent to which you have made an investment in a court and you have not reaped the benefit of your investment. And now is a good time to do that. The filing fees of the CCJ are very small. It's about $500 to file a case from beginning to end. But in addition to that, our rules have made specific provision to exempt persons who do not have the means to pay those costs to be exempt from paying any filing fees. And I made some inquiries, and as of today, we have already made such orders in respect of about 18 cases. More importantly, the CCJ has leveraged court technology to facilitate and make it easy for people to access the court. And you have had some examples of that, where you can access the court by video conferencing. People don't have to travel to appear before the court. And I had, in fact, another sound bite, but I won't play it tonight, because we reached to the extent where a litigant who was in Guyana was experiencing difficulty in traveling to have their case heard. And we were able to allow the lawyer to stay in his home and access the court from his private computer and do the case fully. So we have done a lot of stuff that makes it easier and cheaper and more efficient for ordinary people to access the court. And as I mentioned before, our proceedings are open and anybody can have access and see them by just checking into the website. Now, I was asked to give a few examples of cases, and there's one case I will mention from Guyana. It was a case of where Elizabeth Ross and Corinne Sinclair. These were two poor ladies, and one of them was quite aged. And they had a dispute about the right to occupy a condominium. It was very important to them. Now, they could never previously have had that matter litigated before Pioneer Appellate Court. The CCJ heard the matter, treating them as poor persons, and we were able to get 2 members of the Guyanese bar to agree to represent them without charging them any fees. And the ladies were able to have their hearings done by teleconferencing without having to leave their home. Now, so as a result of the court's intervention on occasion, bar associations have had attorneys provide pro bono services so that in matters could be ventilated, not afford to have their own legal representation. And the attorneys who have participated in these programs have expressed pride in appearing before their own final appellate court and in providing charitable services for persons who could not afford to pay. Now, another question that apparently is very prominent, and it's been mentioned, I think, by most of the speakers today. And I myself have heard it as I've traveled around the Caribbean. There seems to be a pervading fear as to whether the CCJ will be biased or just and fair. And this seems to be coupled with a distrust for politicians and their reach and influence. Now, we have tried to address this by describing the way in which judges to the court are selected and showing that the politicians have no say or influence in the process, and that the court is financially independent of the politicians, and that the bench is diverse with judges coming from different countries and backgrounds. And the court sits in a group of 5 persons or 7 persons, so that these logical explanations would show the care that was taken to minimize the justification for that fear. But we know that fear is not logical, even if it's very real. And I was reminded of this just a few days ago when I was talking to someone who was close to me, a very intelligent person who had a medical problem, and his doctors insisted that he had to get an MRI in Miami. So he accepted that he needed the MRI, and he paid his money and went to see the doctor. Now, have any of you ever had an MRI or had relatives who had one? They put you in something like a coffin, and then they wheel you into something that covers your entire body. And because it is known that people sometimes feel afraid when they are in enclosed places, they give the patient a button to squeeze and raise an alarm if they are too fearful to continue. They told them that 30% of prospective patients squeeze the button, and that most of them are men. Yeah. All this was explained to him. And he went into the coffin, and as soon as they pushed him into the machine, he squeezed the button. He said he just couldn't help himself. So they took him out, talked to him and tried to calm his nerves. Now, he knew that his fear was not logical. He knew that it was for his own good. So at some stage, he confronted his fear. He told me he knew he needed the MRI. And so he willed himself to take the necessary steps. And he happily reported to me that after he did the MRI, the doctors were able to give him a clean bill of health. But somehow or other, this story seems a little bit relevant to this question of the fears that people are talking about the CCJ. Because there's a level at which there's no rational basis for it. And so I'm asking you to confront your fear and take the MRI now on this second attempt here in Grenada. You know, I recognize that as judges, we are not gods. We are human beings. And as such, we are subject to human frailties. So I understand that it is natural to be concerned. But you must understand that this is true of judges everywhere, including England, and the same Privy Council. In fact, I'm sure that many of you would remember one of the most famous cases that came from the highest court in England, the case of Pinochet, who was convicted by the House of Lords. And afterwards it turned out that the wife of one of the judges who tried his case was a member of a pressure group that was very critical of Pinochet. And there was an international uproar. And they reheard the case and decided to overturn the verdict on the ground of the appearance of bias and to order a retrial. Now, that happened in England. The point is, I suppose it could happen anywhere. In fact, at the CCJ, we have already ruled on a number of cases where the failure of judges in the courts below to step down from certain cases which raise presumptions of bias. Now, we are aware that this is a reality of life, but mechanisms are put in place to address these issues. Today, these issues are not limited to the Caribbean. Now, in the realm of criminal law, for example, there is a perception in the Caribbean that because capital punishment has been abolished in England, the English judges' approach to the hearing of murder cases from the Caribbean, where there's still a death penalty, is dealt in with built-in biases against the death penalty derived from their environment. And the same may be said in relation to the adjudication on gender issues, including same-sex marriages. Now, these types of biases, although implied, are still real and impact on the decision-making process. And it's interesting to note that our people in the Caribbean have not been discussing this in the context of potential biases which may exist in the Privy Council. Of course, one has to distinguish between misconduct, misbehavior, where a judge takes a bribe or is subject to political or other types of influence, and the type of bias which is less conscious and results from the implied influences of our upbringing, our background, and our associations. The CCJ subscribes to the judicial education policies of the Commonwealth Judicial Education Institute. And this is not surprising because I was the president of the Commonwealth Judicial Education Institute. And the current president of the CCJ, Justice Saunders, was the chair of its faculty for the intensive study program for judicial educators over several years. Now, we have been introducing these programs into judicial training at the CCJ and throughout the Caribbean and the Commonwealth. And in these programs, we have sessions where we address this issue by providing judges with the means to identify their own biases and the means to minimize the impact of these biases on decision making. The issue of judicial bias is a very important part of the developing law. And there is now a lot of material instructing judges and the litigants that where there is the potential for or an appearance of bias, even if there is no actual bias, the judge should not adjudicate, but recuse himself and withdraw from the case. That is the law which is applicable and which we are enforcing. The obligation to enforce these principles lie on the bench as a whole and not just on the offending judge. So if one were to resort back to a logical approach to this question, at the CCJ, where judges do not sit as individuals on a case, but when a case is heard at the CCJ, it's 5 judges or 7 judges. There is no room for this type of misbehavior or misconduct. Now, the kind of fear that you all might have has been confronted by people from all over the Commonwealth. Now, those of you who Google stuff can check to see how many countries had their final appeal at the Privy Council up to 50 years ago. Nearly half the world. But when these countries became independent, their citizens confronted this problem and decided to abolish appeals to the Privy Council. Do you know that today, apart from 8 countries in the Caribbean, there are only 4 other independent countries in the world who still go to the Privy Council as their final court of appeal? Did you know that? And what makes that even more embarrassing to us, to me, is that those countries are small islands. The biggest one is Mauritius in the Indian Ocean, with a population of 1 million, smaller than Trinidad. And the other 3 are small island states in the South Pacific. The biggest of which is Kiribati, with a population of 110,000. Not much bigger than Grenville. And Tuvalu, with a population of 10,000. That's the company we are in. Everywhere else in the world has already abolished their final appeals to the Privy Council and established their own court to provide final appellate justice. So I think that when you're looking at the issues of trust, I think that this is a good time to confront these issues and to say now is the time for CCJ in the Caribbean. Now, Mr. Master of Ceremonies, I don't know how much time you want me to spend here, because if the audience is interested, I could go on and on. But do you think I've said enough, or how much time should you give me? About 5 minutes? What I had done was, somebody had always asked me to address the issue of how would the CCJ impact ordinary citizens in their daily life. And I started going through the judgments of our court. And I found a lot of cases which demonstrate how our court has had an impact on the daily life of ordinary people. And let me give you a couple. One of the things that we talk about here a lot is corruption in public office. And the CCJ had a case from Belize. Florencio Marin and the Attorney General, where two former government ministers had transferred a lot of land well below the market price. And the CCJ confronted that situation and said that the Attorney General had a right to sue these people to recover the money to pay back into the consolidated fund. That's something affecting the daily life, addressing an important issue. And in fact, when we made that decision, there was nowhere else in the world where that principle of law had been established. What had been the previous rule was that you could take criminal proceedings against them for misfeasance in office. But the ability to sue them to recover the money to pay back to the state, we were the first court in the world to make that ruling. Then there's a case called Gibson from Barbados. Now, Gibson was accused of murder, and the evidence against him was purely circumstantial. It really was, they found a bite mark on the body of the deceased, and a dentist said that the shape of his mouth, he made the bite mark. That's the case against the man. And he was said, look, I'm innocent. And he wanted to hire a professional scientist. The profession is called forensic odontology. But he couldn't afford to hire somebody to check out the circumstances. And that matter reached us. And we ruled that the obligation in the Constitution to provide adequate facilities for a fair trial require the state to pay for the expert to make the necessary studies to give evidence before the court. Now, these are something which affect people in their daily life before the courts of our countries. Another case that we had was, we have been speaking about one of the big problems in our society is delay in the criminal justice system, and how many of our young people spend much too long in jail waiting for their trials. And what happens after they are tried? Let's deal with a case, for example, where they were guilty and they were convicted. What's been happening is, in the past, that the time they spent on remand was not counted in the sentence. And we took a ruling that when somebody is convicted and sentenced, the time they spend waiting for trial should be calculated as part of the sentence. Then, of course, you've heard of the Shanique Mary case. We had cases where we dealt with the indigenous peoples in Belize, the Maya leaders case. We had a case in Barbados dealing with spousal rights. Now, I'm not quite certain if that case is exactly applicable in Grenada, because to some extent it was based on a statute, the Succession Act in Barbados. And I don't know if it is identical with the Succession Act here in Grenada. But that act made provision for people who had been cohabiting for more than 4 years to get certain rights on inheritance if the partner died without leaving a will. And we made a very important case on this matter, affecting the lives of many people who had been affected by that. Then, well, the last case I mentioned, because I can mention lots of cases where the work of our court has direct impact on the lives of people on a daily basis. We had a case, a magistrate's court case, and I don't know if this is applicable here. I'm sure it must apply in these situations, must apply here. And again, it's a family dispute about land, where they had a chattel house on the family land. Well, they had about 4 houses on the family land. And, they had when the old matriarch died and left a will, the person who claimed to be beneficiary of the will tried to evict her niece, who had a house on the land, and got the magistrate to make an order for her to remove her house from the land. And when the bailiff went to move the house, the bailiff went back and reported to the magistrate that this house was not a chattel house because was attached to the land by concrete. And you know, this case still had to come before us to make an order to prevent the house from being dismantled and destroyed and so on. So what I'm saying is that these kind of issues never reach the Privy Council because people just can't afford to go there for cases like this. and having the CCJ adjudicating on matters of this nature. And these are cases which affect people in their everyday life. And that's what the court is standing for. As Mr. Noel said, this has nothing to do with party politics. This has to do with what is good for ordinary folk who need justice in their daily life. It benefits every party. Now, well, I must even say something which I hope you take this slightly humorously, because our decision was not really based on politics. But the opposition party in Barbados was very pleased with the case we did for Vento's voters' right. Here was a situation where Vento's and a group of other persons in his category, they wouldn't put them on the electoral list. General election is coming up. And so the electoral list is now being managed to deny people the right to vote. This case was filed before the CCJ. At 5 o'clock on the Friday afternoon. And the reason why that was so important was that under the law, the electoral lists were to be closed on the Monday. Now, just think about that. If this was here, in almost any other court in the world, the registry office closed at 4 o'clock. You cannot file a case at 5 o'clock in the afternoon on a weekend. You have to wait until Monday to file the case. But because at the CCJ, we have an electronic filing system to make it easier for people to access our court, he was able to file the case through our website at 5 o'clock. And our staff, who have been trained to be responsive, was able to manage the filing at that time from their home. You know why? I forgot my mobile phone with me. But our system in our court is accessible on our mobile phones. So when a case is filed in the court, our electronic system draws our attention to it, and we can manage it wherever in the world we are. So by 9 o'clock, 9:30 that night, every judge on the court had read all the papers. Nobody had to go and print out copies and jump in a car and drive a bundle here and there. All of us were able to access it on our mobile phone or on our laptop computer or our iPad. And we were able to give case management instructions, which led to the case being heard on this Sunday, 2 days after it was filed. And we gave our judgment in time for the electoral register to be collected. So this has nothing now to do with one party or the other party. This is an issue which is affecting the rule of law in our society, which everybody benefits from. So I think I should maybe stop there, because, as I said already, when I was challenged with the question this morning, I went and I searched and I found several cases like that, where the work of our court has an impact on the daily life of people in the community. But maybe I should pause now and see if there are any questions. No questions? Sorry. Anyway, so long as you have the microphone.
Good evening again, Justice Byron.
Thank you.
And thank you for coming. We had a pleasant little chat there this afternoon,
Yes.
this evening.
Mhm.
Thank you. You have given very compelling and exacting reasons why the CCJ is an outstanding court. And speaking for myself, when I was in the transition program at Hugh Wooding, I had occasion to actually visit the court. And I remember being astonished when the guide took us through to the courtroom. I had never seen court technology like this. And I remarked that even in the federal court in New York, where I sometimes brought a case or two, I had never seen technology like this. And I know it doesn't even exist at the United States Supreme Court. Unanimously, across the political, cultural, social, religious spectrum. I can't speak for the rest of the Caribbean, but I think here in Grenada, we support the CCJ. The problem is with the bill.
The bill?
The bill.
Mm-hmm.
The bill in Grenada. I just want to point out a couple of things because I know other people have their own remarks. The agreement, the CCJ agreement, makes poignantly clear, and you are familiar with this, that where there are ratifications or amendments to the bill, to the agreement by the heads of government, that those changes must come back to the countries who are under the appellate jurisdiction of the court to be adopted via the same constitutional provisions that they got in the court by. Our bill in Grenada does not allow for that procedure. In fact, the language in the bill states that the agreement and all its changes are adopted. I'm suggesting that in the drafting of the bill, we ought to mimic the same language that is in the CCJ agreement. And I would respectfully suggest that this is not a technicality. Because we could have a potential situation where we are having
Oh dear. Did you kick something down there?
1, 2. We could be having a situation, Justice Byron, where every few years we may be having referenda to adopt ratifications or amendments to the agreement. But my big concern is this. If we have this wonderful court, extremely good judges, and I think in the Senate there probably is an apology owed to the people at the CCJ, because I heard some rather troubling arguments in support of the bill that have to do with the judges at the Privy Council, their race, their color. I think we don't need to do that to convince people, my fellow senators. We don't have to make those kind of arguments to suggest that the CCJ is a better option for our people. We don't need to have these narrow arguments about people's race and so forth. If we have this great court, Justice Byron, why do we give the right to the contracting parties, that is the heads of government, why do we give them the option to change the agreement? After all, we have this great court. It's paid for by the trust fund. Get out. Leave it to the judges, the commission. Brother Ruggles, the process. you know, you're right, President Trump, President Obama selects judges. But they have a process of comment where once the judges are selected, Justice Byron, the public at large, the American public, can comment, I'm for this judge. I knew something about this judge when he or she sat in the high court I think would make them unfit. I know something about their background that would make them unfit. We don't seem to have that transparent system. I'm suggesting that we bring some transparency in, and for the contracting parties, they should get out. They should get out of the court. You've described it.
Excuse me a minute. I don't understand your comment because we have had the selection process analyzed by academics, by international jurists all over the world. And everybody has agreed that it would be a backward step to have a politician nominate a judge to the court and then have other people comment on whether his nomination is good or not. So I must confess that I can support that thought.
You mean, what do you mean by other people, Judge?
No, you said that when Trump nominates a judge, people have the opportunity to comment on the judge. And I presume that you're referring to the sexual complaint that is being made about his recent nominee.
No, I'm not referring to that at all. I'm simply referring to the process by which broad spectrum of the legal community can voice their support or lack of support for the judge, not based on any
yeah, but they're voicing
charges.
the support of somebody selected by a politician.
Yes.
And I'm saying that it is generally agreed that it would be a backward step to have the judges selected by a politician. What we have instead is not an absence of process, but a completely different process, where when there's a vacancy, nobody handpicks anybody. Anybody in the world can apply to become a judge of the CCJ. Now, it might surprise you. No, well, we have evidence. Because here we have a Caribbean Court of Justice. And on the court right now, you have a judge from England. And you have a judge from Holland. So when the CCJ advertises a vacancy, people from any part of the world can apply. And when they apply, it goes before the commission, who has established a whole network of investigative processes, including having them present copies of their judgments, copies of their work. There's a wide-ranging network of references. There are associates who have the right to comment on these people. And then there's a process of evaluation, eventually leading to competitive interviews and that sort of stuff. So there is a process which is conducted by independent experts within the region. Now, so there is a process like that, which has been commended by almost every commentator. So I don't necessarily like to get involved in discussions like this with an argument in a public discussion of this nature. But I think that one of the issues that why I mention it in this way is that every way I've gone, people have been complaining that one of the reasons why they are afraid of the CCJ, because they are afraid of the influence of politicians on the decision-making process. And we have been trying to explain that the politicians are totally excluded from the court. They don't have any say in the selection of judges. They don't have any say in the financial management of the court. So the suggestion that you are making would play right back into what people are saying they're afraid of.
But Justice Varyn, doesn't the agreement
that forms the court, doesn't it permit the contracting parties, that is the heads of government, to make changes to that agreement?
I don't understand. Well, every agreement can be changed. An agreement is a voluntary exercise.
No, fair enough, but the heads of government, the politicians have reserved the right.
No, it's not a question of reserving a right. An agreement is something that is voluntary. So any agreement normally provides conditions, even legislation, even the Constitution itself. In fact, what we're doing right here now is changing the Constitution. And what is relevant to my way of thinking is that not that there's a right to do that, but that there's a process which guarantees that the interests of the public are protected. Now, I don't think that the issue that there's a right to change the agreement established in the court is itself a problem. The court is being established now for all of these years, and what is being grappled with is the methodology for implementing the agreement. It's very interesting to me that I think the Attorney General hinted about it today. Now, when you look at countries around the world who have the Privy Council as their final court of appeal, I mean, I don't know anywhere else besides Antigua and Grenada where they have a referendum. When Canada abolished the appeals to the Privy Council, there was no referendum. When India abolished the appeals to the Privy Council, there was no referendum. When Singapore abolished the appeals to the Privy Council, there was no referendum. When South Africa abolished the appeals to the Privy Council, there was no referendum. When Australia, New Zealand, you go down, countries around the world. Now, but nobody has been discussing that. Why is there a referendum in Angola? Why is there the need for a referendum in Grenada? And I was very interested in the way in which Mr. Noel approached Brown, because it bothered me. Look here, Prime Minister Mitchell won the election with a clean sweep. He did not get 2/3 of the vote. Mayor Motley won Barbados with a clean sweep. She did not get 2/3 of the vote. Gaston Brown won Antigua. What I'm saying is that the requirement for 2/3 majority is very onerous. And that's why I commended Mr. Joseph, because it was in my mind and I did not know how to say it. One party cannot win a referendum on the CCJ, because no one party can get 2/3 of the vote. So this has to be, as Mr. Noel said, country above petty politics. So you need to have, so from my point of view, that was a discussion which I found very fascinating, Mr. Noel. And I'm glad that you had the courage to put it on the table.
Just, Judge, can you clarify the comment or the inquiry I had about the process of coming back for the in the constitutional procedures by which member states adopt the Constitution, the CCJ, because we may have, based on the way the bill is drafted, we may have an instance of multiple referendums unless there's some clarity with the drafting.
Now, when you mentioned it to me today, I didn't have an answer to you. I don't know. But I promised you that I would have made inquiries, and I will do so. And I hope that before a day or two is passed, I will have a comment to make. I don't have a comment at this stage, but I will make an inquiry and get back to you within a day or two.
Mr. Attorney General, Brother Ferguson, you may be concerned about Section 104, because 104 seems to eviscerate 103. In fact, I would suggest that when you relook 104, section 104, you may want to say that, quote, save and except for 103, section 103, and then you adopt the language of 104, because as it currently exists, it appears to eviscerate section 103.
Council, that's a very interesting comment you made. I don't know if you have a few minutes, if you could just prepare a little note of your point for me.
I will.
So I would understand precisely the point that you're making.
I will, Judge.
Because that would help me to, make my own study.
Yes, Judge.
And get back in touch with you.
Thank you for hearing me for this length of time.
My pleasure.
Yes, sir.
Excuse me, on a point of clarification. Not counsel. I couldn't help, although I'm a stranger here, I couldn't help be a little bit intrigued at Mr. Ferguson's welcome to the next speaker. So I want to know if the question is for me or for Mr. Ferguson.
I am the next speaker.
I know, that's why
I'm questioning. Greetings.
Thank you.
I think the way the first intervention ended with your comment, it goes straight to one of the many concerns I have. And it's a pity that we are not able to set the record straight within the allocated 30 minutes that is made for audience. But briefly, let me make 2 points. They will be tied. The first one is, I got the very tip of the tail of the broadcasting of the session I had with the TAMCC students. And I made a reference earlier on about the young lady who asked the question. And in one of your comments, your closing comments, you made a point to the effect. In fact, she had asked a question in terms of how many countries signed on to the CCJ. She wanted some more in-depth information. And you responded in terms of, I apologize for having students at this Form 6 level not being familiar with these things. And I think about it, I thought about it, and I think you are also thinking. And I'm thinking to the extent that, to me, it gives an indication of the educational darkness of our people, including the young people. And I want to know if it is an indictment on the powers that be, and here I'm including the government, or an indictment on the educational system, including the CXC. And I will cross this comment, this observation, to one of my substantial points now.
Mr. Roberts, it is true that that comment was made, but I also recall that there were a group of students in the front who protested and said that they knew.
I was not there. I will hold it.
Yeah, okay.
But I just want to make a point.
But some students,
okay,
challenged the indictment that was made against them.
Okay, with some.
Yes.
Setting the record straight. I am seeing that the so-called debate going towards to the CCJ on two fronts. And from some time in the back, and even this afternoon, we have a repetition of the goodness, the merit for going to the CCJ. But on the other hand, as the first presenter started, my main concern is about the bill. The bill. The CCJ referendum bill. The bill, the CCJ, in fact, the Constitution of Grenada Caribbean Court of Justice and renaming the Supreme Court Amendment Act 2018 was actually a bill. It will become an act until. Now, the context, the contents, the construct, and the consequences of the bill need to be in the public domain. The spirit and intent of the Constitution, which you as an experienced judge, must be observed and respect must be shown to the people. One of the leaflets I have in front of me speaks to the requirement of the Constitution. And it says here that the House of Representatives had a first reading. Then they are to debate, and then the bill passed. The same requirement, more or less, is required for the people. Because Section 39 talks about the bill being presented in the House of Representatives and the Senate, then to be passed by 2/3 of the population. The connection I'm trying to make is, why is it that to have the bill is being read and debated in the parliament, but not read and debated in the public domain? This to me is what is it?
On a point of a question.
Yes.
Are the parliamentary debates broadcast on radio and television?
The issue, we don't have a culture of having the parliamentary debates being broadcast. And I repeat myself, we don't have a culture of the parliamentary debates being broadcast. I will repeat myself. In the recent times, we do have some of the parliamentary debates broadcast. And continuing with the culture issue, many persons do not avail themselves to this broadcast. So it's not a culture. Even if it's a culture, I want to submit that the bill should have been distributed and circulated or posted on key government buildings.
Is it online? Is it online? Is it online? Is it online? Huh? Is it online? Is it on the internet? Mr. Mohammed, let me tell you my comment. I don't know what the facts are.
Yeah.
But I was asking whether the bill was online. Because one of the measures I'm encouraging people who I have any influence over is to respect the Caribbean's interest in combating climate change by reducing the
paperwork. Yeah.
Right. So I asked whether or not the bill was accessible online. Was it on the internet? And could people just click and read it in that way? Because frankly, from my perspective, I would like to recommend that rather than distributing paper copies.
Thank you. What I would say is the writ for the CCJ referendum was issued by the Governor General today, the 18th of September. The writ, together with the bill, was sent to the Supervisor of Elections, and he in turn has sent it to all returning officers in the various constituencies. And the writ, copies of the writ, together with copies of the bill, will be circulated and posted on police stations, schools, and different buildings. So from this week, you'll be able to see hard copies of the writ and of the bill. And besides that, on Friday, The writ, or copies of the writ will be on at least 2 newspapers, and they will also be on the Gazette.
Great. Now, continuing. Bullet 8 of the leaflet says that the electorate will be asked to vote yes to the bill. Again, the substantial point I'm making. The action required of the people, the electorate, is to vote on the bill. However, the opportunity to debate the bill, for me, is in question. And it ties to the first presenter from the floor, that we need to have open debate so that ordinary people can understand and they might be able to give an input. And I will try to end by saying...
Mr. Roberts, no, please, I'm enjoying this very much, so forgive me. I'm not trying to be, I'm just being myself. I don't mean anything bad about my comment.
Yeah.
I might even make you laugh if you listen to me carefully.
No problem.
Mr. Ferguson, it seems as though Mr. Roberts is challenging your legal acumen to some extent. I'm just trying to figure out what's going on with this last point. Because from my way of thinking, the definition of public debate is whatever definition you use. I think I am participating in a public debate tonight. So I was just wondering if I could have got somebody to assist in just trying to thresh out Mr. Roberts' perception. Is he suggesting that there should be some kind of...
Let me help you.
Thank you.
Let me help you. And Mr. Forrester is coming to help me too. Listen carefully.
Yeah.
We should, and we are going to set the record straight. Point 1. Point 2 is that everything has to be done within context. So when we talk about public debate, what we have in here, as I say, is a public debate. But it's at a different level. I am calling for a public debate in terms of the referendum bill on the CCJ, which we're going to vote for. I am saying the people need to know, need to understand, need to ask questions, and need to make comments so that bright persons like yourself can guide me and others in the public as to say what is in the bill is good. Because going to the CCJ, there's a route, there's a way to go. And this way to go is paved in the bill. And there could be things there that we vote for, which is not in line with what we are thinking. So this is, I'm talking about the context and getting the record straight. I know we have public debate, what we're doing. Let us concentrate on what is in the bill. And by extension, the bill makes reference to other documents of CARICOM. The brother raised one of them. The agreement establishing the CCD. And I think it's very important for the average Grenadian to at least have a fair idea as to what is involved. Let me hear my brother Ferguson.
Excuse me, you're taking over my role as the judge. It was my job to invite him to talk. Mr. Ferguson, can you respond, please?
Thank you. Yes. Well, first of all, let me say, I don't disagree with you that the bill ought to be available. It is my understanding that the bill is online and available. So I would not disagree with you that the bill ought to be online, available to all. And there's supposed to be Facebook and Facebook website, all for, in fact, not just on the, and that's the point I'm making, the underlying point, that this is a national issue. This is not a government issue, it's not a party issue, it's not the committee's issue. And therefore, it should be the responsibility of all, including your organization, to get that bill available and give it widespread publicity. Right? So that's the first point. So I'm not disagreeing with you on that point. Two, the debate, you seem to have shifted positions from what I heard, snippets of communication I've seen from your articles and programs on radio, because exactly the points that Dennis is making. This is the debate happening now. And you know why that debate is happening now? The debate is happening now because a date has been announced for the referendum. You know, I had an experience just after the last referendum, the week after. As everyone knows, I was back on regular programming and speaking about the referendum and the CCJ. Actually, I was speaking on the CCJ. And a lady called in at the night and said, "Mr. Ferguson, how come is now you're telling us that about these things about the CCJ? Say, if I knew all of that, I would vote in favor of the CCJ." So that was a week after the referendum. And I said simply, "Well, madam, that's what I've been saying for the last 12 years. Probably you are not listening. You listen to me tonight because the referendum is over and all the different partisan positions were out of the way. But the reality is, this is the debate taking place. And neither the government is responsible for causing that debate to happen, or the committee is responsible, though I think they should play a lead role. But all organizations, it should be our responsibility. I say so about the bar all the time, that the Bar Association should be leading these debates, because the bar, members of the bar are trained in law. But if the bar is not leading it, then somebody has to lead. Why quarrel if government leads? If you are abdicating your responsibility to lead. And the debates you are referring to that we should have now, and that's why I made special mention of you in the audience and welcomed your self-appointed position that you were going to lead the No campaign. Because I think it's good. That is contributing to the debate. And ultimately, I think the more the people who express themselves make those points publicly, it will give everybody the opportunity to respond and contribute to the marketplace of ideas out there. So that debate, as Dennis said, is really happening now. And I'm really pleased with it. On the point that Jerry made earlier and yourself, unfortunately, I don't have the documents with me, and I don't think we get internet inside here. But the issue of the main thrust of the bill, is the Grenada moving to the appellate jurisdiction of the CCJ as its final court. Right now, the final court is the Privy Council. Sections 103 and 104, in fact, 104 sets out the kinds of matters that would go to the Privy Council. And really and truly, what is happening is that the constitutional amendment seeks simply to replace where the Constitution refers to as the Privy Council with the Caribbean Court of Justice. So the question really to be answered in a referendum is, do you, and I'm putting it in my own crude words, do you support Grenada acceding to the Caribbean Court of Justice as its final court? So once you understand what the role is of that final court is, really replacing the Privy Council. And I don't think there are fundamental differences. I will look at the legislation Again, certainly. But that is what the objective of it is. Now, ultimately, as Jerry indicated, it's an agreement. It's an agreement among heads to establish our own regional court, because somebody has to pay for it. Who will pay for it? The money has to come from somewhere. So the governments, they have collectively raised those monies, and they are the ones who would have entered into the agreement in 1973 in the first place, and subsequently amended it to provide for the Caribbean single market and economy. So it's the heads must do it. At the end of the day, remember, this is a regional thing. It's not a national thing. So if we decide that we could do our own thing in Grenada, what would happen to the regional concept? There must be collective agreement among the heads ultimately. The politicians must play a role at some point. So this thing is not taking away the role of the politicians. In fact, members of parliament are politicians, and they have to, the Constitution requires the parliamentarians or the politicians to debate first in the lower house and pass by 2/3 majority. Then you go to the upper house, all politicians. You can't avoid that. But ultimately, what it goes for, if it is passed there, it goes to the people for approval. That's what it's going for. Not to be passed, but for approval of what the politicians did in Parliament, because they are the ones who will be passing the bill.
Thank you very much. I will end by saying, it's not so simple. I just humble submitting that. To say that the bill is all about just removing the Privy Council and replacing it with the CCJ. Hence the reason why I'm saying it is important for the populace to see the content and understand the content and construct of the bill.
No,
Secondly,
I'm agreeing with that. I'm agreeing with you on that point. Yeah. I have no problems.
We have a book, we have the title, the name of the book, but it's reading the book. What's that substance? Secondly, with all respect, the learned judge, retired judge, and I'm not judging you, but I think I'm getting that he may not be getting on board with the demand I'm asking for the bill to be in the public domain for discussion, on the basis that one, apparently he was not so, he couldn't remember much what the first presenter was trying to bring out. And he listed many countries which they linked from the Privy Council with such a referendum. So in other words, having a so-called CCJ referendum bill appears to be foreign and out of reach. And Tom Gordon keeps saying that Grenada has this provision in the Constitution. So, because it's not of faith, another custom, because all the countries, including those in the Caribbean, the four of them who are in the CCJ in the final appellate court, never had a requirement for a referendum. So we are unique. And we have to ensure that what is done properly, and we can be the shining star for the rest of the OECS, for the rest of the Caribbean, and the Commonwealth. And let us get it straight. So you're not only talking about the goodness of the CCJ as an institution and what the trust and the faith, but let us ensure that what we put in there in the CCJ bill is what is good for us.
And who determines that? Who determines that?
We the people.
Right, but
we the people.
Right,
we the people.
So what I'm saying, what I'm saying is that we may argue and debate about the interpretation of any bill. In fact, sometimes these interpretations go all the way to the Privy Council, and even the Privy Council is divided 3-2 on the interpretation. So ultimately, at the end of the day, we can be just going around in circles.
But if you want the bill to pass, the Bible says, let us reason together. So you are the expert, I'm the layperson. Right. Let us look at the bill together. I will eventually accept what you say once you give me clarification.
Okay.
And I will finally end by saying, I think it was Jamaica and St. Lucia. Some countries which do not really require a referendum, they can just get into it. With respect for the people's intelligence and sovereignty, my retired judge, the government, although they sometimes play politics, they say even though they're not required for a referendum, they will bring the issue to the people. This is how significant and patriotic and important a political issue is. And this is what I think we have to take on board. And let us see how we can help Grenadians, help the advisory committee, educate the people on the bill, and don't limit the public discussion to about the goodness or the integrity of the CCJ. Thank you very much.
Okay, before Ms. Ferguson speaks, I'd like to indicate that you will be the last speaker for the evening, after which we'll have to close. Thank you.
Okay, thank you. Good evening, gentlemen.
And I think I'll probably, before you ask the question, I'll give Robert that question to answer. Could I have Robert answer that question?
No.
Interact with the public sufficiently. Yes, thank you. Yes, it's happening. You know, we need to get this right. This is about our democracy. This is about our constitution, of our independence. And we need to do it right. We're having some conflict of ideas, and it's happening, you know why? As the Jamaican singer said, walk on by the morning, can't get good at evening. This CCJ thing started bad, undemocratic. When the ministers went to the island and discussed, came up with a very good idea, they did not come back to the people. Way back in 2003 or 2005, this was on the table. Where were we, the people? So you see, we need time and we need to take it slow, because the people must come along. Now we have these consultations. I went to the launch, same thing happened. There are so many people there who wanted to make contributions, they were not able to. We hear again, same is happening. We need to check that.
Okay, I hear you, and we'll allow you to make do you have a question that you wish to ask after Ms. Ferguson?
I will mind.
So I'll allow you to to ask a question. Okay.
Okay, good evening. All right, well, Robert, I think you know what I come in with. So I'm very privileged to have had the opportunity to hear Justice Byron. And I see the leaflet that has been distributed this evening on the mechanisms for the independence of judges. What I do have a problem with President Sir Dennis, is the regional Judicial and Legal Services Commission itself. And since that time, my confidence has not been restored in the commission. I certainly am not attacking the integrity of the judges, but I have a serious problem with that commission. And very much what I would like to ask this evening, is what mechanisms we have put in place to ensure that this does not happen again. And I talk specifically about the membership of that individual on the commission, who was a citizenship by investment agent. At the same time, holding the post of ambassador to the OECS to CARICOM, to the Association of Caribbean States, and also on the Board of Governors of the Eastern Caribbean Central Bank. And what I found out just about 2 weeks ago, and it's quite ironic, he was one of the 2 civil society representatives that would have been chosen by the Director General of OECS and the Secretary General of CARICOM. So clearly one cannot say to me that the Director General of the OECS and the Secretary General of CARICOM did not know that this individual was a state functionary. So how could he have been nominated to the commission as a civil society, as somebody from civil society? Let alone, which says something about the absence of due diligence process or it not being robust enough. Because in my mind, that is an untenable conflict of interest. And I would go further to say I feel strongly about it because of this odious nature of our citizenship by investment program. And I think it taints the integrity of the commission. And as I said, I would just want to ask what mechanisms are in place to ensure that these things don't happen again. Because you also indicated, well, I would say here there's a serious conflict of interest, and and I would just compare that with the comments you made about bias or the perception of bias. So conflict of interest or the perception of conflict of interest. So that's my issue on the Regional Judicial and Legal Services Commission. I hasten to say I am not a lawyer. I am just an ordinary member of the public. But I too have read the bill, and I am struggling to understand why is it that the agreement which establishes the Caribbean Court of Justice now becomes a constitutional instrument. It has replaced the appeals to Privy Council order. So, and I've done some homework. So I would just share, for example, how one of those amendments would now read. Parliament may alter any of the provisions of this Constitution or of the court's order or the agreement establishing the Caribbean Court of Justice in the manner specified in the following provisions of the section. That is how the amendment just reads. So this issue has been raised by the former 2 speakers, and I want to add my confusion to it. To let you know of my confusion, and to say and to agree that we do not have enough technical presentations, because as I said, we need lawyers to help us understand this. We need lawyers to help us understand this. And the third question, sir, and this is directly a question, on the issue of the development of the Caribbean jurisprudence, I noted in the original, the rules of the original jurisdiction, judges' deliberation, that the only opinion that is delivered is the majority opinion. And I wondered why, if we are talking about development of jurisprudence, the minority opinions are not also delivered. Thank you.
Well, first of all, I thank you for allowing me not to categorize the first two matters you discussed as questions. And so I'll deal with the last one only. There is a lot of mixed opinions on the question that you have raised. But one of the issues has to do with the fact of certainty of the law. And the idea that was given for the regulation that was introduced was that because the court is the final adjudicator, it was very important to ensure that the rules emanating from its decision were certain. So the reason for that's basically the reason for it. Now, it doesn't prevent intellectual discussion and academic research on other perspectives, because our genuine interest is in development of Caribbean jurisprudence, and that implies that there will be modifications and changes from time to time, so that the opportunity for discussion of issues exists and will be taken on board appropriately. But the rationale for that rule has to do with maintaining certainty of the regulations that are enforced managing CARICOM. So that's the rationale behind it. Now, somebody over here said they wanted to ask a question.
Yes,
to me or to somebody else?
In the interest of time,
You just wanted to comment. Is it a comment or a question?
It's a comment. I have a question. I don't know. It's time. It's a question of time.
Excuse me. Let me take the opportunity to offer an apology. When I went to my seat, it was not a comment on what was being said. But at my age, I have to protect my knees.
Yeah. But as you're there, perhaps I can ask a question to you, because
okay.
I'm happy to see you, and I appreciate to hear from you here tonight.
Mm-hmm.
But I'm also disappointed.
Okay, tell me.
I'm disappointed because I see you as, and you are, part of the justice system in the Caribbean here for many years. A person looked up to as one who can make a difference, especially when you have conflicts. Now, in this situation here, I'm wondering if you're on the right platform. You see, we are told in the system that the judiciary is independent and should not be influenced by the politicians. You represent, I think, the judiciary in this capacity. And given the debate that is on, perhaps it could be a wise decision if the judiciary, the CCJ, organize their own public forums rather than join in with the committee. The committee has already taken a position. They say yes. Right. The executive, same. The parliament, same. Now, who is for the people? Who is speaking out for the people? Now, a better format can be worked out. That the committee should be the one speaking. For the people, to the executive or to parliament. In other words, I'm hearing debate. Why should the committee be debating with the public? The committee should come with all the facts and information that is available and give it to the people. And the debate should be among the people. You see? So the role of the committee, in my mind, should be to sensitize, to educate, to inform, not to get into conflict with the public. That is what is happening now. And the CCJ, as you said, is people we're talking about. They too, because this, as I said a while ago, that was organized, I think it was the lawyers who brought this to the table. We heard about a treaty, the Treaty of Chagarama, the revised Treaty of Chagarama, where this idea of CCJ was born. And we don't know much about it. From the contribution made by Jerry here tonight, I can safely say that the majority of persons in this room couldn't really appreciate it because we don't know.
Excuse me, sir. Forgive me for not knowing who you are. The comment you made just now makes me inquire, what is your field of operation?
Media.
You're in the media? Okay. Why that's relevant for me? You see, it's very interesting you raise the issue of the Treaty of Chaguaramas, because I have found from that is one of the more inspirational documents within our region. And it's been a matter of some interest to me that it's not widely read. Now, it's available to everybody. You can get it by just going online, and you can download it. And I have found from my own personal experience that each time I read it or read sections of it, I gain something of benefit. So I agree with you, if I can agree with you, or permitted to agree with you, that it is a document which should be people should know more about it. But again, they have to read it themselves, and they can easily access it by going online.
Well, the politicians know the public that they are dealing with, you see? And online, yes, but I don't think that the people who put politicians in power online.
But you can help. You're in the media.
Good. Well,
August, I'm teasing a little bit, so let me take it.
I do, you see? So the public education is critical. And this is
judicial and other work. And so we have tried to create a forum that would allow people to have access generally. Then we tried to cultivate the new trend in technology by setting up a Twitter account, and we set up a Facebook account. And so so what we have been doing is allowing access to all of the information about the court, and allow people to view the operations of the court. So you can look at every case that has been happening at the CCJ. You can actually see a video of everything that happened in the courtroom. And then the other thing that we do is that we give public lectures. So basically, we have limited our activities to the dissemination of information on the website, written, and through the process of public lectures. Now I wish that we could have done more, because I feel that if we were managing the referendum story, we would have used different strategies. But the point is that the role of a court? You see, what we say to people, and what I say to anybody, that I'm available to respond to questions, I'm available to participate in discussions, but I don't know if it's right for me to try to initiate them and to come and say, look, you understand the difference we're trying to do. So I hear you, but you know, you still have to sort of balance what's the right response to the issue you've raised.
Yes, well, I am not questioning the effort of the CCJ, you know, in terms of the dissemination of information. I think our leaders should be more proactive, on our media in that regard, you see? Because certainly in our experience here in Grenada, we don't know. And we need to improve that.
Well, are you willing to, you see, I am one of these people who listen to how people talk to see if they are volunteering to help. Am I hearing something like that from you? That you want to get on board in the action?
Well, I'm on board. I'm on board, you see?
Well, that's what you sounded like to me.
Because this is what I'm saying here, is what I'm hearing out there.
Yeah.
You see? And especially where we want to get into the Constitution, because you said that there are a number of countries that made their changes without tampering with the Constitution.
No, I didn't say that. I said without having a referendum.
Sorry.
The referendum requirement in Grenada is not exactly unique, as Mr. Roberts said, but I'm aware of just Antigua and Grenada in the region where there's a requirement for referendum. And I'm not aware of, Reynolds, you can help me, but I don't think there's anywhere else in the world where there was a requirement for a referendum to the link from the Privy Council. And it bothered me when I looked at the Constitution. And I don't know exactly the reason why, but it's bothered me that's the position. And that is why Mr. Noel's point is so important, that this cannot be regarded as a party issue. So the way the Constitution was framed, it was based on the premise that this would be a non-party political issue. It has to be viewed as a national issue. So that is how I see it.
It is a national, but it is political. You see, well, I heard the Prime Minister on a newscast today stating that it is non-political and we should national, same sort of language. But you see, anything to do with government is political. It's political. You see, it's the science of government.
It's just not
it's the art of governance.
Political. It's political.
It's political. It's not party,
right?
Not partisan. So we must let our people know that it is political issue.
Right. But I really want to. I'm really happy you raised the point that you raised, because there's a point I'm trying to get across. In terms of responsibility, whose responsibility it is? Everybody takes it as somebody else's responsibility. It is all of us responsibility. So if you are in the media, for example, you need to have your Media Workers Association vibrant on an issue like this and organizing your debates every night on radio stations throughout the country and seeking to get information from whatever perspective in the newspapers. This is not a job for a voluntary committee, for us doing it alone, you know. You know, part of the problem is that everybody feels that we're getting big money for this. We are doing it as voluntarily as everybody else is doing it. And because it's a national issue, and I say more than national issue, because whichever party comes to power, if Mr. Joseph Roberts becomes Prime Minister in the next 10 years, he'll have to face this issue, because we have to account to CARICOM, just as all other nations have to do. How come we signed an agreement in 2001, 17 years ago, to establish a court? We have paid for the court. What steps are we taking to join the court, irrespective whether we need a referendum or not? It is our duty. It is everybody's duty to do so. So the issue about speaking of the court coming, can you expect a committee to come out here and say, hey, pros, these are the pros, these are the cons, make up your mind? How could we do that? How realistic is that? You know, I always ask, why don't parties, when election time come around, tell everybody vote your conscience? Everybody says vote me. This is something that we're taking steps to join because we have a legal obligation to do so. So what's the problem in saying vote yes? So we come to an audience and say, these are the no's, these are the positives. You make up your mind. You know, I spoke to one of the leading lawyers in India, a constitutional lawyer, and I was explaining about, we were having an engagement over the referendum in 2016. And he was just puzzled during the discussion. He said, why? He said, you go into the people have to vote to decide eventually these changes. I know his answer, but he said, well, you would never get it. And at that time when we were speaking, he thought it was majority. When I told him 2/3 majority, he said, but how is that possible? How will the people understand? You know, at the end of the day, it's a massive task. You can't depend on the committee alone to go about and explain these things for the people. So our society is as strong as the institutions of society are, and it is all of our role. So we should ask ourselves the question, what are we doing? What am I doing? And what are we doing, as opposed to the committee not doing X and the committee not doing Y? I think if we take that approach, we will ultimately, at the end of the day, see a much richer debate out there.
Well, I agree that we all should do our part. We all. But you see, all right, let's send it in.
Okay, thank you very much, ladies and gentlemen. I now invite Ms. Wendy Edmond to move a vote of thanks. Ms. Wendy Edmond.
Mr. Chair, on the issue of Privy Council, I think for the, remember that Grenada delinked itself from the Privy Council some time ago. And there was later a Privy Council ruling which indicated that it was quite all right. I think we ought to let Justice Byron know that. And on the issue of accountability, I heard Ruggles say, my dear brother, that we have to account to CARICOM. The heads of government is the highest decision-making body of CARICOM. The heads really need to account to their people. And how many of them have joined the appellate jurisdiction? Just an observation.
Yeah, and I agree with that, and I agree with the point made earlier that, you know, discussions on CSME and what CARICOM leaders do, there's insufficient public education on that, and there needs definitely to be more public education on so many of these fundamental issues out there. But on the question of the linking from the Privy Council, I think the answer to that question is that we do not need a referendum to the link from the Privy Council. but we need a referendum to establish a new court to replace the Privy Council. So there is no referendum needed to delink. Can delink tomorrow, but then we'll be left with no final Court of Appeal.
Pleasant good evening. My task here this evening is very simple. It is simply to say thanks. Honorable ministers, government officials, to our distinguished guest speaker who graced us with his presence in the capacity as a former president of the Caribbean Court of Justice and also an advocate not just for fairness of justice, but has a special passion for the CCJ. We say thank you, sir, for living the comfort of your home in St. Kitts to be with us here this evening and imparting your knowledge with us. Once again, a warm Grenadian welcome and thank you. To all our invited guests, thanks for accepting our invitation to be here this evening to share in the process of public education on the CCJ. Mrs. Michelle Still, thank you for presenting Sir Dennis Byron to this wonderful audience this evening. Ms. Booker of SADO, thanks for your welcoming remarks. Mr. Ruggles Ferguson, we thank you immensely for always doing justice when it comes to the dissemination of information on the topic of CCJ, a topic that is very dear to your heart as a Grenadian citizen. Mr. Glenn Noel, we say a hearty thank you for your deliberation here on the topic of the CCJ, and we trust that you will be an advocate within your community to ensure that persons understand the cause. We thank you again, and especially for invoking that oneness, that spirit of unity among us as we move forward to this cause. Dr. Lawrence Joseph, who is also the chairman of the CCJAC, and all other members of the committee, thank you for continuing the public education on the subject of CCJ and bringing the meeting to St. Andrew. We also want to say thanks to Mr. Robert Branch for chairing this evening's proceeding. It was wonderfully executed. For the lovely entertainment here this evening, we say thanks to Rainbow City All-Stars Still Band. The media, thanks for your coverage, and to you, our wonderful audience, we say thanks for being here. Without your participation and attendance, this event would not have been possible. Once again, we say thank you, and of course to all law enforcement officers who were ensuring our security here tonight. We say thank you. Get home safely.
Prime Minister says moves to have CCJ as Grenada's final court of appeal is urgent. Details to this story and more coming up in the National Reports. Welcome back with the news in details. I am Wendy Edmond with the National Report. Grenada's Prime Minister says the move to accede to the CCJ as the final court of appeal is an urgent one. He was addressing students at the T.A. Marisha Community College during an interactive session with former CCJ President Sir Dennis Byron. Sir Dennis, who is in Grenada as the country prepares for the November 6th referendum, will also deliver the keynote address at the first public awareness meeting organized by the CCJ Advisory Committee at Deluxe Cinema in Grenville. The meeting is designed to create greater awareness on plans by Grenada on its accession to the CCJ as this country's final court of appeal. Government believes that since the CCJ bill received the majority of votes and attracted the most attention at the last referendum, it is fitting to reintroduce the process.
There are persons who may be concerned as to why are we back here at this time? What is the necessity? Some are stating. What is the urgency? I think I would want to say this. This is as urgent as you could find it.
Dr. Mitchell cautioned against politicizing an issue that is of national importance. He says acceding to the CCJ will demonstrate our true independence.
This is not a political issue. It's unfortunate when issues of national importance are before us, sometimes petty political interests come into play. This is beyond and above partisan political interests. This is not an NNP issue. It is not an NDC issue. This is a national issue.
Sir Dennis spoke to the subject of biasness of judges. He says the CCJ engages in sessions that will tackle these problems.
I've been involved in judicial education programs, and we know that every human being has biases. When you become appointed as a judge, you don't stop being a human being. And we pay a lot of attention to that. In our judicial training programs at the CCJ, and those in which we have a chance to give, we devote sessions helping people to identify what their biases are.
The Caribbean court system is back to a state of normalcy following the devastation of Hurricanes Irma and Maria in 2017. That announcement was made by Chief Justice Dame Janice Pereira, DBE of the Eastern Caribbean Supreme Court on Tuesday during the special court sitting to mark the opening of the new law year 2018 to 2019. The legal fraternity in Grenada joined its counterparts in St. Christopher and Nevis and the rest of the OECS via simulcast. Chief Justice Pereira said the court system in several islands were hard hit in 2017, resulting in the cancellation of the new law year opening and various court procedures.
The court building as well as the residence of the High Court judge received some damage. The court facility was forced to remain closed for several weeks whilst repairs were made and utility services restored. This physical interruption, though, did not prevent the hearing of urgent applications by telephone and video link as soon as telecommunications were restored by the direct routing of hearings to a judge located in St. Lucia. Full appeal hearings were also conducted in person and via video link from St. Lucia. Today, the court's facilities are once more fully functional and were first to resume full operations after the storm.
In Grenada, High Court Judge Madame Justice Paula Guilford called for proper court facilities to be given high priority to address the many challenges faced by the fraternity, including the backlog of cases.
It is about time that proper court facilities are constructed or a suitable building designated to house the courts. No longer should the court staff be placed in cramped and unbearable working conditions. No longer should our legal documents be left to decay because no proper arrangement has been made for their storage. No longer should there be uncertainty as to whether one would be able to sit today or any other day because the facilities that house the court may not be conducive for its purpose. The health and safety of all court users must be a priority.
The opening was guided by the theme, Challenges, Opportunities, and Resilience. The ECSC paving the way to a modern and efficient judiciary for the Eastern Caribbean. This is the National Report. More news after the break.
The house was shaking. Then said the story here, babe. Crack, and the roof had gone.
Man, I was so scared, I nearly wet myself.
Only those who have lived it can truly understand the devastating fury of a hurricane's wind.
The house across the road just get up and roll over.
Hurricane force wind. It's a hazard. Hazards. Take control. Reduce your loss. You can hurricane-proof your home. For example, make your roof more wind-resistant by using screws instead of nails in its construction. Find out more about hurricane force winds and other hazards at your local disaster office. A message from the National Disaster Management Agency and SEDERA.
Welcome back with the National Report. Grenada has welcomed its 90th group of Peace Corps volunteers. The first batch was received in 1967, 6 years after the Peace Corps was originally launched by U.S. President J.F. Kennedy. Of the 17 inducted on September 6, 2018, 12 will remain to serve in Grenada, while 5 others move on to St. Vincent. Annette Moore has the details in this report.
I promise to foster an understanding of the people of Eastern Caribbean. I am a Peace Corps volunteer.
Thank you.
Class of Eastern Caribbean 90, my new colleagues, who stand on 89 generations of volunteer shoulders. I wish you the best life can offer and success in the work for peace.
Triano spoke to the volunteers at the induction ceremony on September 6th, along with other officials.
45 years and over 400 volunteers later, through their unstinting efforts, U.S. Peace Corps volunteers have left indelible footprints in almost every sphere of our society. It is therefore with distinct pleasure that on behalf of the Government of Grenada, the Ministry of Education, Human Resource Development and Religious Affairs, that I extend a warm welcome to the 12 volunteers comprising the 90th group of Peace Corps volunteers to the home of the oil drum, Grenada.
With the cooperation of the Ministry of Education, because I know there's a lot of work that goes into bringing all of these people in here, putting them in schools, finding places for them, and then getting all the materials that we have to get in order to make changes. So we definitely appreciate everything that you do for us.
I look at each of you and the faces that you present, because you will be the face of America. You will be the ambassadors in your community. You will be the people who show Grenada what America is all about and what we stand for.
During the ceremony, certificates of appreciation were presented by the principal officer at the U.S. Embassy, Stephen Fromm, to the local homestay providers who volunteers live with during the initial stages of their stay. Volunteers also took part in a fun exercise demonstrating their new Grenadian dialect skills and knowledge of culture. For the National Report, I'm Annette Moore.
And that story ends the National Report for today, Tuesday, September 18th, 2018. From all of us in the newsroom, I am Wendy Edmond, thanking you for viewing.